Good morning, Lucy. Good morning, ladies and gentlemen. The Goff Lecture was instituted in 1990 by the City University of Hong Kong to celebrate the commencement of its Master of Arts degree course in Arbitration Dispute Resolution, which is now a Master of Laws degree program led by Mr. Christopher Toh. The first lecture was delivered in 1990 by Lord Goff, Lord of Appeal, who then consented to the series bearing his name. Remarkably, all the distinguished speakers for the previous 24 Goff lectures have been men. So when Neil and I were discussing who should deliver the 25th lecture, and we both thought that Lucy was an obvious candidate, it was a bonus that we should have our first woman deliver a lecture within this prestigious series. And I dare say that Lucy really needs very little introduction. At the start of this year, she joined Arbitration Chambers in New York, having spent over 7 years before that in Asia, first as head of the Freshfields Global International Arbitration Group, and then as director of the Center for International Law and professor of practice at the National University of Singapore Law School, where I had the pleasure and the privilege of being her colleague. Lucy is president of ICCA and a vice president of the SIAC Court. She has previously served as president of the American Society of International Law and a vice president of the ICC Court. She has represented numerous private and public clients in investment treaty and complex commercial arbitrations, and also sat as an arbitrator in many cases. So really, it's my great pleasure to have such a distinguished arbitration specialist with us today, and I now invite Lucy with pleasure to deliver her lecture. Lucy, please.
Thank you. Thank you. At the start, I want to thank Chen Hang, whom I know from my time at NUS, and Neil Kaplan, whom I know from my time practicing international arbitration in Hong Kong and many other places around the globe. I also want to thank everyone from City University of Hong Kong and the Hong Kong International Arbitration Center who have made this lecture possible, and those of you who are attending or listening under difficult circumstances. You've heard that the Goff Lecture was started in 1990, and there have been 24 Goff Lectures since. According to the CityU website, on the occasion of the 24th lecture by Neil Kaplan, the Goff Lecture provides, and I quote, an excellent opportunity for discussion and exchange of ideas among practitioners and academics in the arbitration field, end quote. Now, I checked, and it was almost exactly 1 year ago that I received the kind invitation from Neil and Cheng Han to deliver the 25th Goff Lecture, scheduled for the week of the VIS moot competition in March of 2020. Now, the VIS did not happen, the Goff Lecture did not happen, many things did not happen in March and have not happened since. So this gives me the honor of being the first to deliver the Goff Lecture remotely. I am really pleased and a little bit jealous to know that about 20 of my friends and colleagues are gathering now in the Hong Kong HKIAC offices so familiar to me, and will be able to enjoy that traditional Goff opportunity for excellent discussion and exchange of ideas in person. As for me, I am in my study in Charlestown, Rhode Island, the US, and I've been trying to find some link between me and you over the ether. So I thought about it this way. Unlike Johnny Veeder and other Goff lecturers, I did not have the privilege of knowing Lord Goff. So maybe my closest connection to Lord Goff and the English judiciary is that Charlestown, which was incorporated in 1738, was named after King Charles II. The surroundings are a little bit international, though, as well, because we have neighboring towns, I kid you not, that are called Galilee and Jerusalem, and others named after our indigenous peoples, Quanquanatog and Narragansett. So that's one honor, being a remote speaker. I have a second honor this evening for you as well. As was mentioned, I am the first woman to deliver the Goff lecture. And when I looked back at the email of invitation from Neil, I smiled because he said this. He said, "We just do not know how this happened, but can think of no one better to redress this egregious error. It will be no consolation, but your predecessors are Lord Goff, Rogers, Lord Bingham, and on and on. An egregious error, it has been, and I'm honored to be the first woman, and I know I will not be the last. But I have to dare to disagree with Neil on one point. It actually is consolation of a sort to read the list of prior Goff lecturers, which magnifies the honor and the challenge to be at this virtual podium. And I must say, I found it poignant that the two Goff lectures I found to be most relevant to my topic were those delivered by two giants whom we have recently lost, Johnny Veeder and Pierre Lalive. Now, Professor Lalive wrote that the honor of delivering his lecture was, and I quote, matched by the exceptional difficulty to follow 8 distinguished lecturers, end quote, with the even more exceptional difficulty of following even more than 20 distinguished lecturers. I proceed to my topic, Arbitrator Temperance, David Caron's Rule of X. So 2 years ago, in September 2018, the University of California School of Law at Berkeley hosted a conference called The Elegance of International Law in commemoration of my dear friend and another giant, the late David Caron. I was invited to give a keynote, but on a substantive topic, not in commemoration or in memoriam of David. So I decided to see what David had been researching that I hadn't kept up with. And on SSRN, I found the text, and it was as delivered, not finalized or edited for publication. I found the text of the opening lecture that David had given to the entering class in September of 2017 at MIDS, that being the, of course, the Masters of International Dispute Settlement Program at the Graduate Institute in Geneva. And if you could put slide 2 for me, please. You'll see a picture of David to remind you, and the title of his lecture. I just have a few slides tonight with some longer quotes and to liven things up. I was intrigued by the title, Arbitrators and the Rule of X, and I became even more intrigued as I read his speech. And I took note that David stated at the outset, and I quote, that this discussion is only starting and in his view presents a much deeper agenda than currently set out, end quote. So I knew then that if David were still with us, I would have picked up the phone and called him and said, let's co-author something together. But as he's not, I have decided to develop the David Caron Rule of X on my own. And at Berkeley, I decided that I would try to bring the David Caron Rule of X into our international arbitration lexicon, like the Alan Redfern schedule and the Neil Kaplan early opening and the less well-known Lucy Reed retreat. That explains the second half of my title, Arbitrators and the Rule of X. I'll illuminate the first part, the first half, Temperance, shortly. Now, David introduced his MIDS lecture topic to be, and I quote again, the far-flung array of individuals who serve as international adjudicators and arbitrators, whom he found to be the most difficult group in international courts to predict, to give a logic to. David didn't agree with other academics that the primary driver for international arbitrators is reappointment for its own sake. He focused his research on the quest to be reappointed by dint of virtue, by the virtue of reputation. Now, after David noted and I guess dismissed what he called the overstated claim that international arbitration is a mafia or a club. He focused on what he called the disruptive practice of overcommitment as underlying much of the current criticism of international arbitrators. It's overtrading that can make it impossible for a tribunal to find a hearing date for more than 2 years and can cause arbitrators to arrive at hearings unprepared and depart on Friday afternoon before deliberations. It's overtrading that can force parties to wait years for awards and can lower the overall quality of international arbitration. Now, David was quick to explain that this situation is more nuanced and widespread than the particularly busy calendars of particularly popular arbitrators. He said this, and I quote, "It includes the practitioner who has only 2 arbitrations, which are difficult to mix with the unrelenting demands of clients. It likewise includes the academic who has only 1 or 2 arbitrations, which are difficult to accommodate within teaching schedules." David then cataloged external responses to the evils of overcommitment. The HKIAC, the ICC, ICSID, other arbitration institutions now routinely require that arbitrator candidates document their availability, for example, by disclosing exactly how many cases they have as chair and as wing, and by filling in calendars 3 years out. Now, as I've discussed with Neil, one wonders sometimes how robust those disclosures are. But regardless, in David's view, these external requirements serve to provide a minimum of information to the parties. They are not what arbitrators professionally should demand of themselves and each other. Slide 3, please. What is needed, according to David, is internal control. Central to my lecture is this, David's posit that arbitrators need to reflect on the amount of appointments they are reasonably able to handle. For the issue posed by overcommitment, the needed internal commitment is gained by what I call the rule of X. He suggested that all of us, and particularly existing arbitrators, set a number, X, as the upper limit of cases that he or she is capable of responsibly sitting on at the same time. The prize is a reputation for excellence. Now, David emphasized that there is no uniform number X. Given that individual circumstances and capacities vary tremendously, X has to be a subjective factor that varies for each arbitrator. For example, it's going to depend on things like experience, age, energy. Are you arbitrating full-time or part-time? What's the nature of your other work? Is it academics? Is it practice? What's the legal culture? What's your tolerance for using tribunal secretaries or your willingness to use tribunal secretaries? And of course, X should vary over time and over a career. Now, David did identify one critical variable for X, and that is whether one is sitting as chair or as a co-arbitrator, because being chair, of course, can make the work exponentially harder. At Berkeley, I added this. Next slide, please. I said that if David had had more time, no doubt he would have expressly elaborated on more variables: treaty versus commercial, complex versus modest, personal factors like family life balance, intellectual challenge, and the sheer fun, which David often talked about, that can come with sitting with certain other arbitrators and hearing certain counsel. Now, however many the variables and however subjective the exercise, David considered the consequences of actually having an X benchmark to be profound. First, having an X forces an arbitrator to evaluate each prospective appointment more critically, especially when one is at X minus 1. Second, if an arbitrator at X turns down additional appointments, in his words, the good news for arbitration and the parties is that she would have a strong incentive to focus on working and finishing the X cases. And third, having an X leads arbitrators to serve, I think he said, more robustly in the role of arbitrator and improve the quality of his own work and arbitration in general. David connected this to what he considered to be the true cost of overcommitment, namely, and I quote, overcommitment is the number of arbitrations, overcommitment in the number of arbitrations is undercommitment to a particular arbitration, end quote. Now, on the surface, it may seem that the rule of X is relevant only to well-established arbitrators who have the luxury of being able to afford to decline arbitrator appointments. However, this would be a mistake to read it this way, because David several times said that in his view, when arbitrators at X or close to X turn down an arbitration that's relatively small or of relatively little interest to them, they make those arbitrations available to a bigger pool of younger and more diverse arbitrators in the long run. Now, I'm not naive. It obviously will take much more than the rule of X to increase diversity in international arbitrator appointments. I do hope, though, that David's optimism will prove warranted, and we will see appointments that I and others turn down going to a more diverse and broader pool of arbitrators. Now, my plan tonight, my time, today, your time, is to elaborate on rule of X variables and implementation. But for now, I want to focus on the nature of the rule of X. It's important, and I'll probably say it too many times, it's important to understand that David Caron's rule of X is a rule of self-discipline. As self-discipline is, I think, often undervalued in our commercial market, I decided that I should look beyond David as a source. And I couldn't find anyone else, by the way, in the legal literature who had written about this self-discipline in arbitrator caseload. So I decided I should look, as I say, elsewhere. And I decided to look to classical moral and ethical philosophy of self-discipline. Now, not surprisingly, the Greeks were forthcoming. And I should here disclose that embarking on a refresher course in classics, I have had the benefit of a daughter, Dr. Madeline Reed Glennon, who has a PhD in ancient Greek archaeology and art history, who may be watching tonight. Hi, Maddie. To refresh us all, the main ancient Greek philosophers, Socrates, Plato, and Aristotle, questioned what it meant to be good and how to reach, in Greek, eudaimonia, which is roughly translated as happiness or well-being. This comes through examination of the virtues, including justice, moderation, and courage. Eudaimonia is different than our modern definition of happiness because it's related to purpose and correctness rather than emotion. In Aristotle's Ethics, which was written circa 350 BCE, a main point is that virtue is essential in itself and not as a means to an end. So things like honor, intelligence, pleasure, excellence are chosen for their own sakes, but primarily to secure eudaimonia. Stoic philosophy, founded by Zeno around the 3rd century BCE, goes even further. The central tenet of Stoicism, and it's different than the modern use of the term, is that the only thing necessary for goodness and happiness is moral virtue. Stoics believed that eudaimonia is achieved through adherence to the virtues only, whereas Plato and Aristotle believed that external things such as health and wealth would contribute to happiness. Now, if we were arbitrating now, I venture to say that since arbitrators need both health and a reasonable amount of wealth, we would be ruling for Plato and Aristotle here over Zeno. But more seriously, Plato, Aristotle, and Zeno alike considered self-control to be the central virtue. Much of Hellenistic philosophy is concerned with the concept of, I'm trying my pronunciation here, sophrosone, which is roughly translated as temperance. Sophrosone means temperance in the sense of inner balance and self-control, not measured against outside expectations or responsibilities, or certainly not against outside external laws and codes. Now, just to make sure everybody's clear, I am not speaking of temperance in connection with the social movement of abstinence from alcohol. I'm a moderate drinker, and unlike you at 9 in the morning after this lecture, I'm sure I will have a glass of wine. But I think temperance in arbitration in that respect would probably make arbitrator collegiality a bit less, well, it would dampen arbitrator collegiality. Now, if you would put up slide 5, which is just for fun, this is, if anyone is watching who knows Washington, D.C., this is a photograph of something called the Temperance Fountain in Washington, D.C., which was donated in 1882 by a Mr., let me check, Henry Cogswell, who was a San Francisco dentist and a temperance crusader. He thought that giving access to cool drinking water in fountains around the city would keep people away from whiskey. Now, I put up this slide especially because, quite ironically, the building right behind that statue, which has the 2 spires on top, is, or actually was, the huge Apex liquor store, which made all of us laugh. They finally did move the statue, which was called the ugliest statue in all of Washington, D.C. In the 1980s. Also on the slide, you can see my two Greek terms. So let's go back to Greek temperance instead of alcohol temperance. Plato's Republic, which was written circa 375 BCE, is, as you know, a series of didactic dialogues between Socrates and various Athenians about the ideal city-state. In the Republic, sophrosine is translated as sobriety, or a kind of beautiful order that's linked to self-control. Socrates at first takes issue with the idea of self-control because he says being master of oneself suggests that you can be both master and subject, which is absurd. He goes on, however, to define the 2 parts within a person's soul and mind, the smaller good part and the larger bad part. In a city-state, the good part can be the master over the bad part, and therefore there can be a harmonious securing of sophrosone. Now, I obviously don't have time to share this full dialogue, but as the first woman Goff lecturer, I can't resist offering one bit. Now, if you recall that the Republic is a debate about a perfect society, Socrates and Plato extend this good and bad metaphor of sophrosone to the people living within society. The bad part consists of those who have low self-control, that is, and I quote, the mob of motley appetites, pleasures, and pain of women, children, and slaves, end quote. The good part, of course, is the ruling class of citizen males who are entitled and obliged to rule the others. Enough said. Now, there may be some relevance in another dialogue in the Republic about the significance of self-knowledge in temperance. If you can follow this. Next slide, please. You'll just have to read this for yourselves. What Socrates says is that only the temperate person will know himself and be able to discern what he really knows and does not know, and have the power of judging what other people likewise know and think they know, and so on. And so this is being temperate, or temperance, and knowing oneself, that one should know what one knows and what one does not know. I think that would be, that rings to me of self-awareness of at least a humble international arbitrator. So how, you might be asking, how do these philosophical concepts of eudaimonia as well-being and sophrosyne as temperance inform David Caron's rule of X? Well, as David was addressing the disruptive practice of overcommitment, these concepts underscore the personal responsibility of an arbitrator to determine X as being the maximum number of cases that he or she can reasonably sit on at one time. Now, in speaking of temperance in this context, it's worth remembering that as lawyers and arbitrators, we're members of a learned profession. The legitimacy of a profession as compared to a trade or a craft is that professionals as individuals bear a sense of responsibility to the greater public beyond material incentives. In this regard, I refer you to the work of Professor Richard Moorhead, in particular a 2014 lecture he gave to inaugurate the Center for Ethics in Law at the University College of London law faculty. His lecture was on precarious professionalism. Now, in our profession, an accepted norm is that arbitrators, like judges, are to be diligent and expedient in discharging our functions, including issuing awards. This norm is echoed many places in the 2002 Bangalore Principles of Judicial Conduct and in judicial codes. One example, in deference to our real venue, is that the Hong Kong Guide to Judicial Conduct provides that judges should be diligent and punctual in their duties and deliver judgments within a reasonable time. To revert, I think my last time, to the ancients, the 12 Tables of Rome said this, and I quote, "The setting of the sun shall be the extreme limit of time within which a judge must render his opinion," end quote. So from that vantage point, David Caron's rule of X it's a tool. It's just a tool to assist arbitrators in fulfilling their professional responsibilities, especially expediency. Although awards by sunset after a hearing may be aspirational for most. So now I want to turn to suggestions on how to implement the rule of X. This is something that I've been developing since Berkeley, with a look at modern day social science. And I would be remiss not to thank my former student, Liu Kai-Tai, for his research, and my senior counsel, Lindsay Gastrell, who helped me flip some sections of this lecture around. Hi to both. Now, in case I left you in BCE time, I repeat that the problem David was researching was arbitrator overcommitment. If overtrading risks an arbitrator's reputation, why does she take on too many cases? David observed, based on frank discussions with colleagues, that it's often simply paranoia that underlies overtrading. An arbitrator is reluctant to turn down an offer to serve for fear of not being asked again and being sidelined. I have to say that's not my experience. When I turn down an appointment by saying I don't have the time to give it the attention it deserves, I may sometimes be pushed a little and subject to cross-examination, but I'm always thanked. Another reason for overtrading may be just an arbitrator's inability to say no. Acceptance of any and all arbitrator appointments may be a form of a habit developed actually rationally in the opening stages of building up the book of business as an arbitrator. Of help here in social science might be the work of Charles Duhigg, a Pulitzer Prize winner, who wrote the book called The Power of Habit. His advice is to use the muscle of willpower to break habits. Here, to say no to arbitration X plus 1. A more helpful approach, in my view, is for an arbitrator to take very deliberate steps to calculate his own X at a particular career stage and then apply it strictly. Now, calculating X will require for some accepting fewer rather than more arbitrations. This is a form in social science of essentialism, as developed by Greg McKeown, who wrote a New York Times bestseller called Essentialism, the Disciplined Pursuit of Less. He observes, and I quote, applying highly selective criteria is a trade-off. Sometimes you'll have to turn down a seemingly very good option and have faith that the perfect option will soon come along. It forces you to make decisions by design rather than default, end quote. Now, McKeown adds that we may lack control over our options, but we always have control of how we choose from our options. For arbitrators, this translates, I would say, to the reality that we have no control over what parties or co-arbitrators or institutions will offer us an appointment, but we can control which cases we accept. Now, I have learned that in the process of calculating one's X, it is critical to be, I would say, unflinchingly honest and realistic. Without venturing too far into heuristic theory today, I mention the planning fallacy heuristic, which is our human tendency to underestimate how long a task will take. This applies, I've learned from kind of hard-earned experience, this applies when we take on a new arbitration, and while it's supposedly not supposed to take much time for many months, we find ourselves with a barrage of emergency or interim measure applications. Now, the planning fallacy was coined by social scientist Daniel Kahneman, together with Amos Tversky. Now, I think many of you will know Kahneman's book, Thinking Fast and Slow. For an arbitrator to apply David Caron's rule of X is to think slow, or more grammatically said, slowly. In brief here, the relevant behavioral science is that human beings have two types of cognizant functions. System 1 is fast, automatic, and intuitive, and system 2 is slow and deliberative. For our purposes, system 1 is an arbitrator getting an email or being called on the phone saying, could you take this new case? And automatically saying, yes, I take it, thank you, thinking it might be my last. System 2 is an arbitrator in the same situation, thinking carefully about how that new case would fit in with her existing caseload and her ideal caseload. In David Caron language, thinking to oneself, am I below X now? If I'm at X minus 1, is this case more interesting or more lucrative than another that might come, I don't know, next week or next month or even next year? One way to do this is to draw up checklists. Again, many of you will know the work of Dr. Atul Gawande of Harvard Medical School. In specific, his book, The Checklist Manifesto, How to Get Things Right. Dr. Gawande narrates his personal story of creating and implementing a safe surgery checklist on a World Health Organization project to try to minimize avoidable harm and death in surgery. And then he goes on to detail the proven benefits of checklists, not only in medical work, but also in the aviation, construction, and financial sectors. Dr. Gawande builds on two reasons for human fallibility identified by philosophers. The first is simply ignorance, and the second is ineptitude, which is not being ignorant, having knowledge, but failing to apply the knowledge that we have. And in Dr. Gawande's words, if you would bring up the next slide, he says, avoidable failures are common and persistent. We need a different strategy for overcoming failure, one that builds on experience and makes up for our inadequacies. There is such a strategy, though it will seem almost ridiculous in its simplicity, maybe even crazy to those of us who have spent years developing ever more advanced skills and technologies. It is a checklist. What Gawande says is checklists seem surprisingly able to provide protection against failure because they remind us of minimum necessary steps that even we experienced professionals can miss in our daily life. And it makes, a checklist makes those steps explicit, black and white to be looked at. Good checklists are precise, to the point, and easy to use even in a rush or in difficult situations, and they instill self-discipline and promote temperance. Now, no, it's true, Dr. Gawande did not get to international arbitration in the checklist manifesto, so I'm going to have to do it for you. Here are two checklists that I have been building for myself. Slide 8, please. The first is a checklist of factors to use in calculating X for a given stage of one's career. I'll let you read it yourselves and just flag a few things. The first is, what time frame am I thinking about? The next 3 years, or filling in a retirement? How much money do I need? How much time do I really have for my arbitration work? What are my priorities for family or other personal commitments? What's the balance that I think makes sense between chair appointments and wing appointments? Do I want to do commercial work, public international law work? What balance? Where do I want to go? For me, I've accepted appointments a few times to be able to get to new countries and turned down some because I didn't need yet another visit somewhere else. Another factor is risk tolerance. By this, I mean things like, do I want to take cases where I know the counsel are going to be very litigious and very contentious, and it's just going to be battle after battle. And the last one I have on here, number 9, I think is important. It's to say, when your X changes. So if you're looking at calculating an X at a particular stage, it's important to be honest about your backlog. How much work is remaining from the arbitrations that you already have? Now, the next slide, please, is a checklist on the factors that one would use once one has an X and the phone rings and someone says, would you consider an appointment in case X versus Y, or I should say A versus B? You can, again, read them yourselves. It's getting into more detail about how an invitation to take a case fits into your X calculation. So is it a presiding position or a wing position? Who are the co-arbitrators? Who are the counsel? How much is in dispute, which is a way of having a proxy, if you will, for complexity. What are the likely fees if money is important? I'm looking at my own screen here. Number 8, I don't know, maybe exaggerating to say intellectual challenge. I mean by that something like, is this a new sector? Is this a new area of the law that will be interesting to me? Or is it a repeat type issue where I will feel I've developed some expertise? Again, level of contentiousness. And then you've got to think about your risks in terms of, will you travel to a particular seat? Where are the hearings likely to be? And item 14 was important to David Caron and to me. I know, and that is, will this case overall add interest or even fun to my caseload? Now, I hope many of you looking at this are thinking, oh, I wouldn't put that factor in, or I would put in other factors. And that is the whole point. X is individual and subjective. Now, once an arbitrator has her X factor, the process of strictly applying that factor is kind of like the social scientist's nudge. I'm referring to the work of Richard Thaler and Cass Sunstein, authors of another best-selling book called Nudging, Improving Decisions About Health, Wealth, and Happiness. Despite, I don't know, a rather self-help sounding title, it's a serious analytical book framed against the background of choice architecture. Although actually, as I think about it, in the author's defense, they are not far from Plato's and Aristotle's health, wealth, and happiness eudaimonia. Now, for those not familiar with the concept, a nudge is defined, and I quote, as an intervention that steers people in particular directions, but that also allows them to go their own way. Choice architecture refers to the framework, which is generally a formal regulatory framework that ineluctably influences how we make decisions, from what we buy in the supermarket to what book we read. And here, in David Caron's language, talking about the rule of X, it would be, this would be what they call an educative nudge, a self-initiated educative nudge, which is aimed at informing better personal choices of professional conduct. And you can see that, if you put up the next slide, you can see that in David's prediction that having an X would make an arbitrator hesitant. It would be like a break. X would make an arbitrator hesitant to accept any appointment that puts her or him above X at X plus 1 or X plus 2. And arbitrators that benchmark themselves will be less likely to take on an irresponsible number of appointments beyond what they're able to handle and from which they must dig themselves out. So in the nudge context, where we're talking about freedom of choice and self-initiation, the flip side of that is to think about the role of external rules, of more than nudges. And this is my last general topic. As we speak, literally as we speak, due largely to controversy in investment treaty arbitration, international arbitrator conduct is under the microscope. Ranging from conflicts of interest to issue conflict, the focus is on things like repeat appointments, double hatting, lack of diversity, and arbitrator availability. It's almost natural that in the wake of soft codes of conduct for party representatives in international arbitration, efforts are on foot to craft arbitrator codes. Most visible is the draft code of conduct for adjudicators in investor state dispute settlement prepared by the secretariats of ICSID and UNCITRAL. There's a lot to be said about this draft code of conduct, but my focus is only on Article 8.2. Next slide, please. You can see that this draft article raises the possibility, and it's only a possibility because the whole text is in brackets for comments, raises the possibility of limiting an ISDS arbitrator to an absolute number of arbitrations designated for now, don't get confused, as X, explicitly to expedite decisions. Now, you won't be surprised to hear that I am dead set against any fixed case limit of X for ISDS arbitrators for all the reasons that I'm in favor of David Caron's rule of X. And I know David would join me in opposing a uniform case limit on ISDS arbitrator service with 1 case, 2 cases, I don't know, 5 or 20. Because you've got to remember David's warning that a practitioner arbitrator with only 1 case can still slow down a tribunal more than an arbitrator with many. So I emphasize yet again that the algebra of X is individual and subjective. I know from a published interview that for Professor Lalive, X was 5 or 6 cases. I sit with some arbitrators with 20 cases who always respond quickly and are fully informed. I sit with others who, I don't know if they have a lot of cases or many cases, but they're clearly not doing the hard work. And I sit with others who are very slow, suggesting that their caseload is too heavy. To me, it's very clear, and I've said this in comments, that the field would lose a great deal of expertise by arbitrarily limiting arbitrators to 2 or 5 or any fixed number of ISDS cases without necessarily opening the door to additional qualified arbitrators. Now, I don't want to be misunderstood. I'm not against soft codes of conduct for international arbitrators in general. I think they're probably overdue. And this brings me back to some Goff lectures. In his 1998 Goff lecture called Irresponsibility in International Commercial Arbitration, Professor Lalive predicted that externally imposed arbitrator responsibility would increase. And this is because irresponsibility, meaning the lack of civil or criminal liability, would attract more attention in a narrow juridical perspective and a broad ethical sense. Next slide, please. He observed that there was a time when an arbitrator's activity was not only much simpler than what it is in most international cases today, but rather in the nature of an honor and a public service. Many, if not all, members of the arbitral community were successful men or lawyers. Maybe he meant successful men and lawyers, enjoying private resources of their own and far from imagining that arbitral activity might become a profession. Tempi passati, he said. Now, this also brings to mind Johnny Veeder, who was a leader among those who warned that arbitration practitioners would face external regulation if they did not regulate themselves. And Johnny was a force behind the LCIA, General Guidelines for the party's representatives, for the party's legal representatives. In his 2001 Goff lecture, entitled The Lawyer's Duty to Arbitrate in Good Faith, Johnny observed that clear rules and self-policing are both an essential part of any solution. So with arbitration arbitrators, as well as arbitration counsel, clear rules can and should be complementary to self-policing. In my view, however, a rule setting a universal maximum X case number is too blunt a tool to correct disruption caused by arbitrator overcommitment. More effective would be arbitrator self-discipline, temperance in managing caseloads. And I worry sometimes that people think by this, I mean a return to a golden age of pure self-regulation when mostly older white European men developed and practiced modern international commercial arbitration. We're told that they followed the unwritten code of upstanding arbitrator conduct because each trusted the others to do the same. Well, as Pierre Lalive said, tempi passati. That golden age of arbitrator oligopoly is not the province of David Caron's rule of X. Although I do think that the community overall would benefit if arbitrators follow the rule of X, it is at heart an individual regime. I remember David's hope that the impact of his rule of X would be expansion rather than contraction of the pool of arbitrators. So to conclude, it's not my goal to see David Caron's rule of X included in international codes for arbitrator conduct. His rule of X, unlike the X factor in the ISDS draft code, is a personal compass, at best complemented by the external guidelines that will be coming. Nor is it my goal for the rule of X to become an international arbitrator norm of practice. That would be overly ambitious and presumptuous. As I said in my introduction, my goal is to shepherd the David-Caron rule of X into the international arbitration lexicon, to encourage the use of checklists, to encourage the use of nudges. I'd like to see the process of calculating and using the rule of X become routine in our role as international arbitrators, become and something we think about naturally when we fill out our disclosure forms. As I was going over this conclusion today, I realize I am describing a norm of sort because I'm envisioning a sufficiently sound and shared foundation of temperance, so frassone, to foster a mutual sense of obligation, appealing to self-interest and the well-being, eudaimonia, of the international arbitral community. Given the thesis in David's Mid's lecture that most arbitrators seek reappointment by virtue of reputation, the question arises for each of us. Do I want my reputation to be someone who takes on any appointment offered or someone who is selectively exclusive? No, not to accept all appointments and to manage those I accept well. That question answers itself, although often, including myself, can honor it in the breach. So I expect you want one more answer to one more question before I close, and that is, what is my X factor? I know I said it was private, but I brought up the whole topic, so it's fair to ask. When I spoke at Berkeley, and when I was a professor and running a research center as well as being an arbitrator, it was a maximum of 8 to 10 cases. And I made a mistake that was overly ambitious because many of my cases started at the same time when I left Freshfields, and so the hearings and the award drafting came at the same time. I guess I was a victim of planning fallacy. But now that I'm a full-time arbitrator and more in control, I set my X at 10 to 15 cases, but in carefully different stages and permutations. So I closed my keynote at Berkeley with these words. I'm quoting myself. Going forward, I will be raising the David-Caron rule of X in terms with colleagues. This does not mean asking others for their numerical X, that is understandably variable and private, but instead urging potential arbitrators to identify the relevant factors and run their own X equations. This will be my way to honor David's intentions to develop his concept of the rule of X in international arbitration. I hope that I have started this with this 25th Goff lecture. Last slide, and thank you.
Well, thank you very much, Lucy. That was fascinating. We'll come back to that in a minute. I wonder whether there are any questions from those of you who are present in HKIC this morning. Maybe I'll kick off with the question. If your rule of X was 10 to 15 before the pandemic and when we moved over to more virtual hearings, how much bigger would it become now, or would it change? Would it not change?
A very interesting question. In the abstract, I would say that the caseload of the X could get bigger because there's less travel, less wear and tear, less days spent traveling. But I think that I have to qualify that by saying that there's been so much rescheduling of arbitrations that were started last year as we waited to see what would happen, that 2021 and 2022 are already getting very full. And for myself, I'm limiting new appointments because of that, I don't want to, that sort of bottleneck of old cases right now. You may have, I'm curious what other people think.
Yes. And let me ask you another question, as everyone's very quiet here this morning. Oh, Chan, you go first.
It's early.
Thank you. Thank you for your, I get the podium. Thank you for your lecture, Lucy. Very interesting and also very good for self-reflection purposes. I think one of the questions that I have is, what if, I mean, we're talking about self-discipline. what if arbitrators across the board can't guarantee self-discipline? How do institutions like the HKIAC help nudge self-discipline along without creating overburdened regulations?
Well, I think that institutions should continue doing what they're doing, which is requiring disclosure of information, which David mentioned is very important to the parties, of how many cases do you actually have, how many hearing days are full, how many, if you're in counsel, how many hearings do you have to do as counsel, looking out over 2 or 3 years. And having those be a factor in institutional appointments if someone looks too busy. But the key, I think, is that those disclosures have to be policed a bit. They have to be checked. People have to be more honest and more forthcoming about it. There was a lot of resistance, Neil. I know you'll remember this, and others will remember, about the calendar, which I was a proponent of, and ICSID did it before ICC. People asked not just to say I have capacity for another case, but what their calendars really looked like. And people said, oh, but cases settle. I shouldn't have to tell you that. And the point is, you need a snapshot at a given point in time. The other thing I'll mention, Chian, is that I think tools like Arbitrator Intelligence, more disclosure of how arbitrators are getting awards out and whether they're timely or not, will end up being useful for the parties. But I have to come back and say, David's focus wasn't on that. David's focus was on just because, as a matter of just because, any arbitrator should be responsible about what he or she responsibly can do in terms of a caseload, regardless of being, chastised by head of the ICC or SEAC or HKIAC.
Thank you.
So, do you think that the institutions can help to police this, maybe by publishing the number of cases that they refuse appointments because they see someone is overburdened?
Yes.
Without naming anybody.
Yes.
I mean, rather like you. Yeah. I mean, rather like you, when I'm appointed in an ICC case, I see what the other arbitrators disclose, and I'm frankly often shocked at how many cases they have, and I wonder how they get through the net.
Well, when I was on the ICC court, I was equally shocked by how many people put in their 3 pages of calendars with nothing marked on it at all. They're supposedly entirely free, including every Christmas Day or every Yom Kippur or whatever. I think it has to be taken more seriously. As I say, those sorts of nudges, they're more than nudges, those are complementary to a rule of X, which is sitting down and saying, do I dare say no? Do I dare say no? And if the word gets out that I say no, will people say, I don't want to sit anymore?
I mean, one of the factors in accepting appointments is probably the effect of peer group approbation, which is quite an important factor. Two of your colleagues or friends say, please take on this case. And it becomes rather sort of beguiling, doesn't it? And even though it may be one you don't want to take. How do you deal with that yourself?
Well, it's very hard to turn down invitations to give lectures from people whom I really respect. More than cases, and sometimes they take more work. No, of course that's a factor. And I have accepted cases myself where, even though I thought I didn't want to take on another case, I couldn't say no to having the opportunity to sit with and get to know some people I admire. That's on the checklist. That's on the checklist. And it might be the reason I like the checklist idea is if I'm just on the phone, I might say yes just because of that and not stop. It's like the pledge, stop and think about appointing more women. Stop and say, oh, I will get to sit with those very interesting people for the first time, but I know that I'm 5 awards behind, and so I'm going to get behind with them, and so maybe I should say no and ask for another opportunity. I'm a convert to the idea of a checklist and taking that extra few minutes to go through all the factors before adding the case.
I mean, I'm a fan of checklists too, but can you give me a tip? How do you remember to look at the checklist?
Well, no, Neil, I can't. You just have to do it. I have one, I'm sitting behind a bulletin board. I have one pinpointed up there.
Does anyone else here have a question? No. Well, I think we've probably exhausted the questions. Lucy, can I just say this on behalf of the City University of Hong Kong and all of us here today, as well as all of our virtual viewers, I'd like to thank you for all the time and effort you put into this wonderful lecture. It was so good of you to build on David's work, and I know he would have been proud of your finished product. In this strange world in which we find ourselves today, your call for non-alcoholic temperance and self-discipline is very timely. If ever there was a time for self-discipline, now is that time. If only arbitration could be described as a kind of beautiful order linked to self-control, to use Plato, which you cited, but not just arbitrators overloading with cases, but also counsel and parties showing more restraint and respect for the process. Of course, I could continue on this theme for some time, but it's morning in Hong Kong and most of us have got to go back to the day job, and I'm sure you're looking forward to that glass of wine, which I'm sure you well deserve. So can I close my bit by saying, in tribute to your classical research, gratias tibi ago, lux propter tuum tempus et tuum lepidam scholam, which I'm sure you all know means, thank you, Lucy, for your time and a fascinating lecture. And I think Christopher Toe is now going to close the proceedings. Dr. Toe.
Okay,
thank you.
Thank you, Mr. Kaplan. Thank you, Ms. Reid, for that very sort of interesting sort of a lecture. And also, it's a great honor and pleasure for have you actually do this golf lecture, the 25th. And we apologize because you're the first female. I think it was an oversight from City University in terms of not getting sort of diversity. I'm sure Xian and people like Sarah Grimmer and Caron will remind us in future in terms of, for example, we should have more diversity in terms of our speeches. Now, on behalf of our Dean, Professor Tang, and members of the faculty and the University of City University of Hong Kong, we very much appreciate your time today. And don't be a stranger to Hong Kong or City University. Whenever you're in Hong Kong again, please do come and visit us. On this note, thank you. And last but not least, I must thank Mr. Kaplan for giving us a stimulating discussion in terms of, for example, this golf lecture. And I hope everyone can actually come back to our golf lectures because we're going from strength to strength. And please follow us on social media because we're trying our best as a university to become a sort of top-tier university in the world in terms of delivering prominent speeches like Ms. Reid going forward. Thank you very much.
Thank you.